We provide the insurance that does indemnify them and help them keep them safe. We have never presented them with a bill with its name in for over 100 years. We have worked in good faith in trying to work this out and find a way for them to be comfortable and for the core of our village, the village green, to maintain its position as the village green. In our efforts to do so, it appeared to me that the 99-year lease was the length and breadth of as far as I was willing to go, in that it allowed the church to maintain its position that it owned it. However, we had a long-term lease that gave the control of the property, even though they had the ownership, and we're not fighting there. It appeared to me to be the perfect place for there to be a meeting of the ways. That was rejected as, and we were told by the church that we either agreed to what they presented initially, or that's it, that's all that they're interested in talking about. That gives me great pause. Number one, I do not understand if the insurance is the question. We provide that. I think that this is the center of our community, and we have an obligation. We have an obligation to take a differential position, rather than to simply say, without the assurances that it maintains as the village green on a long-term basis. I mean, a long-term basis, you're giving away without any protection for the village, without there being right of first refusal, automatic renewal, protections that keep this the core of our village. I cannot support, given this is not the first time this has been asked of village boards, and village boards have not entertained it and not pursued it. I do not understand the motivation here. I do not understand the rush here. I don't understand the village. I respect the men I've been working with here, my fellow board members, and whatever they believe in, because I know they research and they find their way, just as I do, in coming to a conclusion. There is no way that I could possibly vote in favor of giving up our village green. On top of that, I have another difficulty, and I seem to be my night. There were a lot of people interested in this issue, and though I can appreciate the fact that Mr. Kins is the mayor, he can do what he sees fit because he's the mayor. I far prefer, and I think that it would be the more right thing to do, for there to be notification to the public that the decision is being made, so that they could be here in order to see the outcome of something that they were so absolutely interested in. The answer, I've been told by some, is that we didn't have a responsibility to hold a public hearing. Well, I think it was right to hold a public hearing, and in fact we did hold a public hearing, and once we did that, I think the public should be notified when the decision is coming down. All that being said, I know these are very difficult, this is a very difficult issue, and now it will be 2-2, and I will close simply by saying the village green has been the village green, and we were given the opportunity to maintain it for well over 100 years. I do not understand this push on the part of the church, and as far as I understand, it has not been presented to the presbyter. Yet at this point, therefore, I doubly don't understand this major push to come to the conclusion. We don't even know if they have the back.
I just want to respond. My basis for this clearly is legal. Kyle said it as well. We get the emotional terminology that keeps being brought in here and calling it the village green. The issue is real simple. We don't own it. You can call it the village green all you want. You talk about us giving up things. We don't have a right to tell them what to do with it. They can sell it tomorrow. We could love to have them put in there. I would love it if they would put in there and give us a right of first refusal. But they have made it very clear that they're not going to do that. They don't have to do it. They can sell it to anybody they want. We can't coerce them somehow into putting something in there that they're not going to put in there because we don't own it. So we're not giving away any right that we have, because we have no right. We have no right to it. That's been clear, it's been clarified. We discussed this with the village attorney. We have no legal claim to that piece of property. So we can talk about giving things away all we want. We're not giving away anything. They can sell it tomorrow. And I understand. There have been a lot of people here that have said that at the end, you can call it what you want. You can call it the Village Green. You can call it the Church Park. They own it. And, I've heard a lot of things brought up here from a legal point of view that are not true. I mean, I've heard, a friend of mine sit here and say that we own the monument, or the veterans own the monument. Dave can tell you, it's a fixture. The monument belongs to the church because the monument is on the land. It's a fixture with the land. So they're in a legal position here. There's a lot of things that we would love them to put in the lease, but there's absolutely no obligation for them to do so. And they have come to us and said, our relationship that's gone on all these years, and this is not a new thing. This was brought up repeatedly when I was on the board before. David has gone back, he just said, this lease was prepared the first time, how long ago?
Probably 3.5 years ago.
So this is not a new issue, and I think at some point it has to come to that.
It goes back to the Wall administration, carried over to Weinberger and down to Mary.
That's it.
Well, in answer, and final, all that I can say is, when I was mayor, this was brought up. And though I have all the respect for the world, Mr. Donovan, the attorney at that point said, we're not entertaining it. We're not signing it. And the board agreed. We were not signing it. If they're going to assert that position, let them pursue it. But we're not going to sign it over. In doing so, you can tell me what you believe to be right, what you believe to be wrong, but I believe in truth that if we had maintained this for over 100 years, that monument was financed, not by the church. That monument was financed by, if you go back into the records, which are at the Middletown Historical Society, it will go back and it will tell you who paid for that monument, that it was not gifted to the church, that it was a gift to the town and village of Goshen. That was it. That was it. So to assert that it belongs to the church, I think needs more further definition. Have we called in? Well, I cannot possibly sign it.
Let me just clarify what my role is. I don't indicate at any time what this board entertains or does not entertain. That's up to the board. I can only give, my role is limited to giving legal advice to the board. When I became village attorney in 2003, this issue was presented to me. The Presbyterian Church said, we wish to enter into different agreements proposed at the time. It became the lease agreement. The first question that I raised is who owns the church? Who owns the land? So I commissioned a title report from Hartburg Abstract, a local title company. That title search indicated a deed into the church in 17 something or other, no deed out ever at any time. I spoke to CTI Abstract, Don Muro, former village attorney, who also searched the title. He indicated to me that there is a deed into the church, no deed ever out of the church into the village. I spoke to John McCary, the director of Real Property Tax Service. John McCary commissioned his own search for his own people because the tax map shows that a portion of that property to be owned by the village of Goshen. What he said to me is he wants to change the tax map because there was no evidence of any title ever into the village of Goshen. I spoke to that board when Scott Wall was mayor, also when Bob Weinberger was mayor, and now when Mayor Higgins is mayor. And I've said, if you wish to assert a claim to title, if you wish to bring an action for adverse possession, we're going to have to bring an action against the church. We're going to have proof. We're going to have substantial proof. We had to have thought the property was ours. You can't steal property under adverse possession. You must think that it is your property. On top of that, every time that for the minutes of all the various sessions that were given to me, now there's also research that goes back to when Pat Boyle was village attorney in the 60s and Reverend Thompson was with the church. This issue was also presented at that time. Each time the Presbyterian Church allowed the village to use that portion of that land, whatever we call it, it was with the proviso that the village shall make no claim of ownership and that the title to this property shall remain with the church. I can only tell you what my research says. I can't tell you to sign the lease or not sign the lease. It's not my job. It's not my role. What you have in front of you now is a demand from the church that you sign a lease. We've negotiated the lease for a period of time. We've negotiated very recently. The Presbyterian Church has said no. There is a draft of the lease that they will sign, and that's what you're considering tonight.
Any further discussion? Okay, maybe we'll vote, voice vote.
Trustee Sharp. Trustee Matthews.
Nay.
Trustee Roddy.